Hello and welcome to Moneylife. This is Sucheta Dalal. I have a question for you this week. Do you think the Securities and Exchange Board of India, which is the market regulator, should have access to your data, or rather to the data of wrongdoers and fraudsters when they talk to each other on Telegram groups and WhatsApp groups? These are end-to-end encrypted. Question is, during SEBI investigation, should SEBI have access to call data records and details? Now, this is a question we're discussing because SEBI has asked for such access. I think we need to look at the broader context of this and what it means to us and our privacy. So, look at the background. The legal framework surrounding what is fair comment, what is influence peddling, defamation, fraud, on social media, and especially where those who are exploiting social media for business gains, profiteering, making profits, making legitimate and vast amounts of illegitimate money, is all still evolving. The situation is further complicated by artificial intelligence, which has a role in distorting information, and how much that is unclear, along with the long-term consequences of machine learning through constant data aggregation. And this data is data that is being spewed out every day by billions of people who all have access to social media. In this environment, we expect the regulator to specifically target wrongdoers alone, go after them, and punish them before they can cheat you, which is a tall order. So the Securities and Exchange Board of India has been lobbying to say, give us access, give us powers to access calls, messages, data records on digital platforms and social media chat groups. They want access to your Telegram chats, your WhatsApp chats, and they have not got it so far. They've made an attempt in 2022. They did it again in 2025. Reuters, the news agency, has written about it. It is pointed out that only intelligence agencies of the government, enforcement agencies, tax agencies have such powers. Essentially, they can even tap your calls, get everything they want about you, demand this information. Market regulators, financial regulators do not have this. Now, Reuters says that SEBI wants powers to take down any messages, information, links, and social media groups if their content violates SEBI guidelines. But these companies, whether it's a Telegram or a WhatsApp, when SEBI asks for information, give the bare minimum that they need to under the Information Technology Act 2000. Beyond that, they even claim helplessness because they say this is all encrypted end to end. That's what you get on WhatsApp every day, the promise of end-to-end encryption, which means SEBI can access metadata. It will know who contacted whom and when, what time were calls made, but not the actual content of calls or messages, especially if you make those disappearing messages live. This makes it impossible to prove fraudulent activity. You can show that so-and-so seemed to be acting in concert with X, Y, Z, but what did they say? Were they talking about going for a movie or were they talking about trades? Is going to be a lot difficult to prove. But SEBI has actually done quite well on this front. It has managed to get WhatsApp messages after targeting specific people who are under investigation and demanding evidence. We have seen this in the recent interim order they passed about Ketan Parekh earlier this year in 2025, where they established fund running, Dabba trades, how Angadias were used, and they have a lot of WhatsApp data and images that are out there, which as part of their order. According to Reuters, even US and European regulators do not have direct authority to remove social media posts, although they can penalize individuals for fraud and misleading advertising. Is SEBI justified in its demand? If I look at it as an investor, I feel, what the hell? Just let them go after wrongdoers, give them the powers that they want. But that can be misused. They can go into an overdrive. They can go after people on a fishing expedition. You can find that you have nothing to do with any scam and your data is being tapped. So checks and balances are absolutely important. Let's look at what SEBI has done so far in terms of lobbying for access to call data records. Earlier, it was call data. Remember, we moved on from fixed phones to mobile. So, what happens, how it bounces off various mobile towers, what are locations. Call data records, CDRs as they're called, is what SEBI wanted in 2012. More than 10 years ago, they wanted also the powers to intercept and tap calls so that it's just easy. Tap into people and then you can go after them. Frankly, this would have been outrageous. But in 2014, and actually through a 2013 ordinance, the SEBI Act was amended, and SEBI now has the powers to access CDRs relevant to its investigation. So it can't go on a fishing expedition. It has to be strictly in accordance with checks and balances prescribed by the law, and not for tapping calls purely based on suspicion. This has gone on. There was a court case. SEBI won it. It's been established that it has the rights. Then in 2018, there was a high-powered committee set up, which absolutely recommended that SEBI should have the powers to intercept calls and electronic records. How they managed to get this high-powered committee to say so, we don't know. But based on this, SEBI again lobbied and said, amend things, give us that power. The government actually was positive about it. We wrote a news report saying SEBI is likely to be allowed to tap phones, but then better sense prevailed, and they were told that CDRs will be available to it through authorized agencies under the Indian Telegraph Act. So checks and balances finally prevailed, while I think it was the P. Chidambaram government that was almost on the verge of giving SEBI these powers. Few years of silence, then in 2022, SEBI is at it again. In 2024, it's asking for these powers. Why is this happening? Because, as you know, the enormous influence of financial influencers, they're called finfluencers, and they have been making crores and crores of rupees by pretending to run training programs, pretending to give hot tips, and they don't even get registered on SEBI. And they've been merrily doing it through WhatsApp and Telegram groups. People are paying hefty fees, getting conned. Once they lose money, they write to the regulator, wonder why there's no action, and want these fraudsters to be jailed. Not so easy, right? Because social media platforms offer complete privacy to fraudsters. Legal frameworks still restrict SEBI from seeking information. It requires them to go through specific channels. We are all yet governed by privacy protections of the IT Act. So let's assume that SEBI is not getting these powers anytime soon. But SEBI will not like it. We need to look at it in the context of what happens. Is the problem big? Yes. Is it gigantic? Quite so, I would say. Scale of financial fraud is significant. SEBI's demand for access appears valid, and its need to combat unregistered financial advisors and influencers is undoubted. How is the question? How do we balance my right to privacy with SEBI's need to go after wrongdoers, right? SEBI has powers to do things, and it has used them. It has taken steps to curb finfluencers. It's framed rules. It's barred unauthorized individuals from offering stock tips. It said no misleading. It says you violate our rules and you face penalties, debarment, and suspension. It has even acted against registered investment advisors who are actually already so worried. They say all their social media activity has to be reported twice a year to SEBI. Apart from this, and this is the main thing that the regulator ought to do, it is monitoring social media, and its crackdown on specific individuals has been based on complaints that it received and what it has found through the monitoring of social media. For instance, in February this year, it impounded 53.67 crores out of 104 crores that were allegedly illegally earned by this illegal investment advisory run by Asmita Jitesh Patel. She called herself, much hyped, called herself the She-Wolf. She ran the Asmita Patel Global School of Trading Private Limited, and all the recommendations that fell foul of SEBI were on Telegram channels under the guise of training programs. SEBI called a halt to that. In December, the end of last year, it called a halt to the influence peddling of a guy who called himself Bap of Charts. So it is acting. It's got powers. It is able to do things. It went after Ketan Parekh also. So it's not as though it is completely hamstrung and handicapped by the lack of powers. So let's look at this in the global context. What is SEBI asking for? What do top regulators in the world have? Because the problem is not unique to India. A recent study by zerobounds.net, in fact, said that online fraud around the world showed that US is the worst affected. So we need to see what powers the Securities and Exchange Commission has. Forget about the US, all over Europe, tiny but very rich countries such as Ireland, France, Malta, Austria, they are high on the list of online frauds in terms of extent of fraud as well as the extent of losses. So regulators worldwide are tightening oversight. They have gone through this debate of privacy versus the powers that they have for unrestricted access to call data on social media groups, private data. Okay. All over the world, the rules are simple. They must adhere to privacy laws. They must follow due process. And this is done to have checks and balances and prevent regulatory overreach and to safeguard our rights as individuals who are not indulging in fraud. So US SEC has no direct access to CDRs, but it can issue civil investigative demands. It can request communication records for specific investigation after it has prima facie established that it's reason to look at it and goes through the legal process of getting permission. It requires basic evidence to seek access. It cannot just go on a fishing expedition. It has used this effectively. In 2022, SEC charged 8 influencers with 114 million in a pump and dump scheme. They again had used platforms like Twitter, now X, and another platform called Discord. It obtained initial evidence from public posts, after which private messages were accessed through the legal process, but no real-time access to do as they please or tap calls. The Financial Conduct Authority of the UK, it's called the FCA. It can also access data under the Financial Services Markets Act 2000, but only for a specific probe with adequate justification and a court order that ensures privacy rights of individuals are balanced with enforcement powers. FCA scrapes public posts on social media to monitor activities that raise red flags. In fact, it has initiated 20,000 actions on misleading financial promotions in 2024 alone. The European Securities Market Authority, called ESMA, is more broader. It's across Europe, so it has no direct enforcement powers or authority to access call data. It can only work through national regulators of individual countries. Again, with all the same checks and balances. Is it twiddling its thumbs? No, it has still cracked down on misleading statements by financial advisors, leading to increased financial penalties. So with these limited powers all over the world, there is an impact, and powers are limited all over the world. No regulator has automatic real-time access to call data or private social media groups. They have to rely on their own investigative powers, work under court orders, keep privacy laws in mind, and they have to remain under control. These legal safeguards are necessary to prevent excessive or random intrusion by regulators into individual privacy and abuse of powers. Personally, I think this is all the more imperative in India because it can be used as a way of taking revenge on people. So SEBI's demands may appear justified given the scale of financial fraud, but it must align with global best practices instead of seeking blanket access repeatedly and acting as though that is a handicap. SEBI needs to enhance its AI-driven monitoring tools, identify red flags on social media, build a basic case through metadata analysis, identify patterns in communication, look at friends and groups which still provide crucial leads for investigation without really going into direct private content. Ultimately, with a court order, it can ask for data under the relevant act. Regulatory authorities must strike a balance between investor protection and privacy rights. We need it. You need to understand it. You may be a victim, but you have to realize that if the regulator is not unleashed to an extent, if it does not evolve with technological advancements and proper legal framework, then your rights can be affected, your fundamental freedoms can be affected. If you agree, be aware of this, spread the word, and subscribe to this channel. Thank you.